All right. It's a minute after, so I think we're about ready to get started. Heidi, good to see you. Good afternoon, everyone, and welcome to our webinar today. I'm Jessica Lee. I'm the Chief Privacy and Security Partner for the firm and the chair of our Privacy, Security, and Data Innovations practice. Thank you for joining us today. We'll be discussing generative AI upsides, U-turns, and understandings, lessons from last year's case law. As we all know, generative AI is rapidly reshaping the legal landscape, and that brings both opportunities and challenges. And so today we're going to look at some of the cases that have evolved over the last year in particular, some cautionary tales that we might have, and like I said, lessons learned. So our goal is to give you some insights into how AI is being used in the legal profession, how to navigate the risks responsibly, and what we can do as a profession to adapt to the changing technology. And we're honored to have New York Law School professor Heidi K. Brown with us today to share her insights. Professor Brown is a recognized thought leader, an educator, and author whose work bridges the gap between law, technology, and then the human elements of our profession. And I will be the moderator for the program. We'll have a few minutes at the end for Q&A. So I encourage you to add your questions or comments into the Q&A box at the bottom of the screen. Throughout the program, if I see something in there that looks like we should insert it into the conversation, I'll try to do that. Otherwise, we'll try to get to them at the end. And if we're not able to do that, we'll follow up separately. So just finally, for logistics, we'll be sharing a CLE code during the program. So make sure to write that down and include it when you submit your attendance form. The link to the form was circulated this morning, but if you need it, you can send Maddie a note and she'll get that to you. So with that, let's jump in and start uncovering the implications of Gen AI in the legal world. Heidi, do you want to run through our agenda for today?
Sure. So we're going to start with just kind of situating ourselves within the legal landscape, kind of talk really briefly about what state bars are doing and what judges all over the country are doing to kind of educate us about what we need to be paying attention to. And then we'll start with the positive. There's some cool cases out there which talk about how we as members of the legal profession and contributors to the profession might use these tools to solve complex legal problems. Then, as reported, we are going to talk about some cautionary tales, just so we're all aware and on the same page about the potential risks, but also how to get ahead of that and not make the mistakes that many of our colleagues across the country have unfortunately made. And then we'll talk about sort of where we go from here, what we can do about this, and again, educating ourselves, because that's really where we all are at this stage.
Perfect. So, obviously one of the key concerns in the legal profession with the use of AI is how to, leverage its benefits without violating things like client confidences or our obligation to comply with the ethics code that governs our profession. So before we dive into some specific examples, could you share with us some context on how some of the state bars and judges are looking at generative AI and the trends you're seeing in that space?
Exactly. So let's start with the ABA. Our obligation to educate ourselves about generative AI really comes from Rule 1.1 regarding competence. And there's already a comment 8 to the ABA rule that says that members of the legal profession have a duty to keep abreast of changes in the law and practice, including the benefits and risks associated with relevant technology. So that's been in our ethical rules for a while. And I thought, we take a look to see where your law firm's offices are located around the country. It's really fascinating. All 5 of these jurisdictions on the screen have that same language in their Code of Professional Conduct. New York has it in Comment 8, California in Comment 1, and then you can see the other jurisdictions as well, where they focus on our duty to get up to speed on the benefits and risks associated with new technology. New York State, actually, the Bar Association has issued an 85-page AI task force report. My students were kind of overwhelmed when they saw it was 85 pages. But they really emphasize that our obligation right now is education, kind of having a lifelong learning mindset. And so the AI task force from out of New York is focusing on collective education, judges, lawyers, law students, regulators, to kind of get to know this technology and see, again, how it can be used for good, but also the potential risks. And then 5 New York State judges and 2 New York-based federal court judges have issued what are called standing orders. We all have a a duty to pay attention to what each judge wants us to do with regard to submitting court documents in their particular courts. So there's some great trackers that are offered by Lexis and also Bloomberg Law, which tell us which judges in every jurisdiction across the country have issued similar standing rules. So again, looking at where your law office jurisdictions are, California also, the state bar has issued a report that is really informative on what we need to do to pay attention to these tools. Judge Nill, a state court judge in Orange County, and then 9 federal judges in California have issued similar standing rules. DC has issued an ethics opinion, as has the Illinois Supreme Court issued a policy. And then in Illinois, again, kind of like California and New York, judges have responded to this. 2 state court judges, the Human Rights Commission Administrative Law Section in Illinois, and 4 federal judges. Each of these judges are handling it slightly differently, which I find really interesting. They're not all saying the same stuff. So that's why it's super important in each jurisdiction to get a handle on what is the judge doing in the court that you might be practicing before, or if you're a transactional lawyer, what is your particular jurisdiction, state bar saying about what we need to pay attention to. On the screen right now, all the state bar jurisdictions that have issued ethics opinions and the standing orders from judges around the country have touched on either some or all of these particular issues. We're going to talk about the, quote, hallucination problem in a minute, but also our duty to make sure that we protect our attorney-client privileged communications, confidentiality, transparency in conversations between lawyers and clients regarding our use, billing practices, how might this change the way we conduct our billing practices. And then we're going to talk about, in some of the cases, how we have a heightened duty of supervision or discussion and communication among all employees within a law office about these tools. And also, interesting things, these tools were trained on trillions of words created by human beings. And thus, there's the potential for bias in the generative AI output because the documents that it was trained on have potential bias or implicit bias because they're generated by human beings. So again, and also environmental concerns. I just saw an article about how much energy these tools use. So these are the issues that are really being flagged in these state bar ethics opinions and the judges' rules.
Interesting. So you promised some positive applications, so maybe let's jump into those.
Absolutely, absolutely. And I just want to notice one thing I've enjoyed having to learn from and using these tools is to generate images. So all the images in this PowerPoint have been generated with the use of AI. And I'm not an artist at all, so I've been appreciating a positive use that it makes me more creative in visuals. So let's jump into a positive use case. Can AI assist in predicting and resolving ambiguities in contract interpretation and language interpretation? So one judge out of the Federal Circuit Court of Appeals in the 11th Circuit, Judge Kevin Newsom, is sort of a trailblazer in this category of a positive use case. In the first case, so he wrote some very lengthy, they're about 25 pages each, but incredibly fascinating if you want to read them. His first concurring opinion came out back in May of 24. And this was a case involving an insurance dispute on whether, it was an insurance coverage dispute, on whether an in-ground trampoline and a retaining wall constituted, quote, landscaping, and that determined whether there was insurance coverage for this particular addition to this person's home. And rather than trying to use AI and then put it into majority opinion, he wrote a concurring opinion where he very transparently talked about how he consulted AI tools like ChatGPT and Claude and others to help him determine the plain language interpretation of this word landscaping. And I'll come back to the September decision in a second. But the reason why this is so fascinating is Judge Newsom said, he has a duty as a judge to make this decision on his own. But he thought with all of this hype and talk, in the legal media about generative AI, could these tools be helpful in helping him determine the plain language of these terms that were the focus of these very complex legal analyses? And he found, in these tools, they are trained on data that reflect and capture how human beings, individuals, use language in our everyday lives. So in addition to like a regular plain language analysis that a judge might do, consulting dictionaries, consulting linguistic canons, he consulted generative AI, which is a word prediction machine. He called them a high-octane language prediction machine capable of helping us figure out how ordinary people use words and phrases. So that was the landscaping case that he wrote those quotes. And then the second case involved it was a sentence enhancement case, a criminal context case, and the judges had to determine the meaning of the phrase physically restrained, because if that was part of this act that was committed in an armed robbery, that would result in a sentence enhancement. And so again, he consulted in a concurring opinion, so he wanted to be really transparent. It wasn't affecting the majority decision. He consulted multiple generative AI tools. I think he tried 10 different searches on 3 different platforms. And this was interesting because physically restrained is not one word that we can look up in a dictionary or a thesaurus. It's a composite multi-word phrase. And so he consulted those tools to figure out what the average citizen would define physically restrained to mean. Just a personal note, I love using ChatGPT as what I call a super thesaurus for the same reason, because we can all consult our dictionaries and thesaurus for word choices, but if we have a multi-word phrase, it's impossible to do that. But ChatGPT and all these other generative AI tools are capable of taking multi-word phrases and giving us multiple meanings and more interesting phrasing about that. Just real quickly, while we're still on the focus of the positive and using these tools for good, other countries are doing the same thing. So in the United Kingdom, there's a team that is looking to figure out if they can use AI to predict how courts will decide disputes. And then judges in Colombia, the country of Colombia, and Argentina have been, again, transparently using these tools to help them, or actually do like a gut check on decisions on an interpretation and making decisions in cases. One involved healthcare coverage, and another one is in the setting of administrative and tax matters. If you're curious about what more judges in the United States are doing to experiment with these rules, there's an American judge, Scott Schlegel, who has a great Substack blog, and the reference is in this screen. One more site that I will give you, there's an interesting article called Generative Interpretation that, again, talks about positive use cases in the context of contract interpretation while we're drafting contracts to game out whether certain words or phrases we're including in complex contracts. I mean, I did construction law for 20 years and our contracts were 80 pages long. And this article, Generative Interpretation, provides a lot of advice in different legal contexts for how to use generative AI to get ahead of potential vague or ambiguous phrases and fix those before they do result in litigation.
Thanks. Wow. So, I mean, it's really encouraging, I think, to see members of the judiciary being creative in this space. But as you said, there are cautionary tales as well. And I'm sure many on this webinar have heard of the hallucinations and the briefs with the fake citations, but let's dig into the details so we can pull out some insights and learnings for this group.
Absolutely. And this is one of the images that I love that ChatGPT gave me for the cautionary tales. All right. So getting the lay of the land. So far in the United States, there are at least 15 different cases in which lawyers have been reprimanded for submitting documents to courts containing hallucinated case law. There are probably more that haven't been reported or that are in administrative agencies that I don't have access to those published cases, but through my research, I've found 15 so far. But let's figure out where it all started. So back in 2023, when a lot of us probably were still hadn't even logged on to ChatGPT, there was an unfortunate scenario. So in a case pending in the United States District Court for the Southern District of New York, lawyers cited AI hallucinated cases in an opposition to a motion to dismiss. But here's when things went a little awry. Opposing counsel, we all review briefs when we're on the other side of receiving a brief, and they were trying to find the cases that were cited in the papers, and they had to call that attention to the judge and to these lawyers, saying, we can't find these cases, we don't think they exist. And so when the judge called out these lawyers who submitted that document, they actually kind of doubled down and failed to disclose their reliance on ChatGPT. So that made things even worse. The judge had to press them to kind of come clean and try to produce what the judge called the phantom cases. And because the lawyers, first of all, made the mistake of citing AI hallucinated cases, but then didn't immediately take responsibility for that behavior, the court issued, this was the first case that issued sanctions around this unfortunate scenario. So I find the sanctions really informative. The court ordered the attorney to send the notice of the court's reprimand to the client. But also, because judges needed to know what was happening, these lawyers were required to send a letter to each of the judges. These are real judges whose names were mentioned in these completely fabricated cases that were just designed by ChatGPT, because ChatGPT is what's called a pleasing machine. It wants to please us. So if it thinks that it can't solve a problem, it will create a solution to the problem. Now, these hallucinations, there are efforts to correct and fix those issues, but at this point, back in 2023, these lawyers had to report to those judges and also pay a $5,000 penalty. So I won't go through all 15 of those cases. It's kind of depressing to read through all of them, and the fact that these still keep happening, even as recently as like a couple weeks ago. So clearly across the country, we're not learning quickly enough. But I kind of categorized the cases in these 4 categories. There have been lawyers that immediately have admitted fault and expressed regret, which is obviously what we need to do. We are all getting to know this technology. Sometimes there are honest mistakes. Then there's a category of the cases, more than just that Mata versus Avianca case, in which lawyers have failed to take the responsibility or explain how the problem happened. Number 3, the category that I probably like the least, is that some lawyers have just blamed their interns or law clerks or junior associates. Do not do that. As a teacher of your future law clerks, I don't like that behavior. And then there are the lawyers who have just willfully just made these things happen, and again, not expressed regret. So I'll just go through a couple of each of those examples just to highlight kind of lessons that we can learn. 2 of the earlier cases last year, again, well, these are good examples. So these lawyers, as soon as they were notified, either by opposing counsel or the law clerks for the judges, I want to flag that because obviously this type of action by lawyers who aren't checking and verifying their sites are putting an additional burden upon opposing counsel and law clerks to try to find those cases, but then take time to point out that those cases don't exist. Luckily, in these 2 cases, I actually cited a Canada case at the bottom of the screen. These 2 sets of lawyers acknowledged the problem immediately, apologized, expressed remorse and embarrassment. The American lawyer at the top of the screen did say that he relied on recent law school graduates and a trusted associate, but took ownership as the supervisor of saying, oh, wow, this means our firm needs to really educate everybody from the most junior to the most senior about these tools, because nobody along the continuum in that particular instance knew that this was a possibility. So in these 2 cases, because the lawyers took responsibility, the court imposed a minimal sanction or a lower sanction than in other cases. The Canadian lawyer was required to pay opposing counsel's costs that were incurred in researching the non-existent cases. So in contrast, lawyers who have failed to take responsibility, you saw the Mata versus Avianca sanction, the $5,000. Here, in this case, this is another New York case, the court really pointed out that, it wouldn't have taken this lawyer much time to just double check on Lexis to make sure that the citations are correct. In this circumstance, the court struck the pleading entirely and then kind of followed up with a sanctions hearing. Similarly, in another case in a federal court in Virginia, this lawyer filed a brief citing AI hallucinated cases. And I really love the quote on the left side of the screen. The court asked the lawyer, the party, to shed light on what the court called a gross error. And the lawyer didn't follow up, or the party didn't follow up. And the court said, this silence is deafening. We really need to talk about what's going wrong to educate not only the parties in the case, but all of us, even on this call today. Here are two examples of the efforts to, unfortunately, shift blame to junior staff, which we don't want to do. We want to educate. Again, a lead attorney in a California case just kind of blamed it on a first-year associate. This case was interesting because the court imposed a financial penalty of $999, which was intentionally $1 below the threshold for reporting the lawyers to the state bar for potential disciplinary action. In contrast, in Colorado, this particular lawyer lied and blamed a legal intern and resultingly got suspended. His bar license got suspended for a year and a day. Moving on to, I think, the final category in terms of the lawyers involved. I might have two more categories, actually. This lawyer, there was actually a standing order in that jurisdiction in September, a couple months ago. There was a standing order in this precise court, and the standing order required the lawyer to submit a certification that they had checked all the citations in the particular brief. And because this lawyer did not attach that certification, a flag was raised, and counsel then revealed she used generative AI to draft the motion that contained inappropriate material, but did not explain why she just didn't comply with the standing order. So again, a sanctions hearing was issued. I think we're almost to the end of the lawyer issues, but I wanted to kind of summarize. Courts are all over the map in terms of the repercussions and the penalties. The financial penalties, at least in the research I've done, have ranged from $999 up to $5,000. Interestingly, there was a case involving a pro se litigant, a litigant who filed a brief without a lawyer, and that was such an egregious situation that court assessed a penalty of $10,000 for a pro se litigant. And then you can see the other results. Some lawyers haven't been sanctioned at all, but just have been sort of slapped on the wrist and said, you can't do this again. This is bordering on negligence. And then there have been other disciplinary procedures. At the bottom, though, briefs have been stricken, cases and appeals have been dismissed because the documents filed with the court didn't include case law that the court could help kind of further things along. Before we shift to the experts, I wanted to just mention really briefly, it's not just lawyers that this is happening to. 16 cases, at least to my knowledge, pro se litigants, again, litigants who don't have lawyers representing them, have been using ChatGPT as well, probably because of the hype in the media that this stuff can do legal work. But as is obvious, the lawyers on the other side of cases involving pro se litigants then have to go through the motions of trying to find the cases. The citations aren't there, the cases don't exist, raising that to the attention of the court staff, who also has to make the effort to point that out to the lawyers. And then I think that Magistrate Judge Gary Stein really raises an issue for our profession to really think about. It's possible, the general public isn't aware that this hallucination problem could happen, and also they might not have access to the legal research tools that we have access to, Lexis and Westlaw and others, because they cost money. Some tech providers have started to think about open access research platforms that will help solve this problem. And I know those have existed for a long time, but it's just something for our profession to think about in terms of trying to release the burden that is going to continue to happen until we raise awareness about this. I forgot two more things I want to mention, and then we can move on. Judges have suspected generative AI use in the context of poor briefing. So even if the cases exist, and so the cases are not hallucinated or fabricated, the citations are valid, if the briefs are just really poorly written, they're bad briefs, as you can see from the case at the top, it can include repetitive language, just state general principles of law, but don't do the art and science of legal writing that we all kind of strive to do. the courts, in at least 2 occasions that I've seen in the context of lawyers and pro se litigants, have pointed out it's possible these briefs were generated by generative AI, and these are not helpful briefs, and thus I'm going to request that they either be revised, or let's pay attention to this and please don't do this again, because it's not helping to further justice in the case.
I think I have like 3 takeaways from that. One,
Okay.
AI is not taking our jobs just yet because it can't, operate at our level. So for those worried, we can exhale a little bit. But probably more importantly, 2 things that were told to me early in my career. One was trust but verify. So
Yes.
cannot be sending out briefs with citations or information that have not been fact checked or double checked. And the second thing was always fall on your sword. So if you do that, it seems like admitting it and coming clean will at least get you on the lower end of the repercussion scale, I guess.
Absolutely. I totally agree with that. And it's even true for, it's not just the publicly available tools that could cause hallucinations. Earlier on, when I was started using one of the paid platform, the legal platforms, I won't say which one it is, but I asked I was teaching a class on generative AI, and I knew about these judges' standing rules, but I wanted to double check if maybe I'd missed a set of standing rules. So I asked a legal platform, an AI platform, what are all the standing rules in the state of New York for generative AI? And the tool came back very confidently and told me, New York Judge Brantley Starr has issued standing rules. And I already knew from my own research that Brantley Starr is a Texas judge, not a New York judge. But this tool came back to me so confidently and said, New York Judge Brantley Starr has issued standing rules. And then the link it gave me was to Oklahoma bankruptcy rules that had nothing to do with generative AI. And so yes, it wasn't a hallucination in terms of the bankruptcy rules exist, but it was still the absolute wrong support for the proposition I was trying to research. So just let's trust and verify, or be skeptical and always verify.
Yeah, and the addition of those links so you can actually see the sources is helpful, because I feel like earlier generations of the various platforms did not have that functionality. So we should definitely be leveraging that.
Absolutely.
But you mentioned, obviously, it's not just lawyers around the legal profession. We're also seeing AI being used in ways that impact, the way we're practicing our cases. So maybe you can talk about some of the challenges you've seen in other areas, like with expert witnesses.
Definitely. So there's 2 cases so far, and again, there might be many, many more, but 2 cases have come across my desk involving expert witnesses also using generative AI tools in the context of their role as expert witnesses, either generating expert reports or serving as testifying experts in a case. So I'll start with a case, again, in New York. I don't know why a lot of these cases are happening in my hometown. So this was a case in a surrogate's court involving a will. It was an estate administration case. And what happened here is that an objector to the estate accounting hired an expert witness to render some opinions about damages related to the estate trustee's handling of real estate. So I think the real estate was to be sold or was sold, but there was a question about whether the trustee breached their fiduciary duty to the estate by selling at the wrong time or for the wrong value, et cetera. So the judge in New York decided that this expert witness's damages calculation was unreliable. And here's why. So the expert transparently wrote in their expert report that they used Microsoft Copilot. So you all might already be aware, but the publicly available tools that at least are the most popular ones are, ChatGPT, Anthropic's model called Claude. There's Google Gemini, which started off as Google Bard, and then there's Microsoft Copilot, and then there's some others. But so this particular expert engaged by this litigant relied on Microsoft Copilot not to do his expert report for him, but to cross-check his damages calculations. But he didn't, in the expert report, explain all the underlying things that we have to explain as experts, how Copilot functions, how it produced the output, what sources it relied upon to do this, like real estate valuation, how the resulting calculations met the reliability standards, which I'll go over in a couple minutes, that are applicable to every expert that we hire who's going to render an opinion either in a report or in a trial. And so the court emphasized that, in the future, the lawyer has an affirmative duty to disclose the expert's use of artificial intelligence, and that any proposed evidence would be subject to what's called a FRI hearing. FRI is a standard in New York state courts prior to its admissions. There are tons of other problems with this particular expert witness's report, and so the judge was not really having it at all. So I thought it might be helpful for us to kind of refresh our recollection about experts, our duty as lawyers to make sure that any experts that we hire, because we all know experts can be expensive and they're very useful, but if they're not going to meet the admissibility standards in court, it's pointless to have the expert be on our trial team. So again, many of us might remember from, if you practice in federal court, you might apply the Daubert or Dober standard. There's also Rule 703, which I'll go over in a second. But in some states, they still apply a different standard called FRI. But basically, it's all the same principle. It comes down to reliability. Under the FRI standard, any scientific evidence put forth by an expert must be based on a principle, procedure, or methodology that's, quote, gained general acceptance in the field. It doesn't have to be universally or unanimously endorsed, but again, it comes down to reasonably relied upon and generally accepted as reliable by experts in the field. I thought this was kind of interesting because I hadn't looked at the FRI standard in a while. Courts will consider prior judicial opinions, articles, scientific or law articles, or expert opinion other than that of the expert that we've hired to analyze whether the principle, procedure, or methodology that our expert is propounding is accepted as reliable in a given scientific community. Rule 703, if you're practicing in federal court, says similar things, slightly different terminology. Our experts have to be helpful to a trier of fact to understand the evidence or determine a fact and issue. And here is what we have to show in our expert reports or lay the foundation for our experts to testify. Their opinions have to be based on sufficient facts or data. Here's the reliability emphasis again. They have to be the product of reliable principles and methods and reflect a reliable application of the principles and methods to the facts of the case. Let me talk about the Daubert standard, and then we'll circle back to why that particular expert didn't meet this standard. The Daubert or Dober standard, again, has this methodology been tested? Has it been subject to peer review? Does it have a known or potential error rate? Are there standards that exist, and are they maintained, controlling the application of this technique to whatever the expert is opining on? And has this expert's technique, theory, or methodology attracted, quote, widespread acceptance within a relevant scientific community? So just circling back to this particular expert issue, in this case, this expert, he relied upon Microsoft Copilot, but there was no way to show its reliability. And based on what we discussed earlier with the penchant for some of these public tools to hallucinate and be a pleasing machine, there was no way to test that. Actually, I think this judge actually tried to do the calculation himself, which is so interesting. But the more he tried it, he got different answers. So that was at least made this particular judge feel like it was not a reliable tool, at least not yet, to help support the credibility of this particular expert's opinion. So I know I'm speaking really fast, so I gotta slow down. The second expert case that is sort of a little bit embarrassing for this particular expert, you all might have read about this, but this happened in Minnesota pretty recently. So here's the context. The state of Minnesota was offering new legislation banning deep fake technology that could influence an election. And so I believe the Minnesota Attorney General hired a really smart person from Stanford's social media lab, the founding director of the social media lab. And this particular expert submitted a declaration in support of the deepfake law, so to help this law go into action. And then there was a lawsuit filed related to this law. And so anyway, this particular declaration, this deepfake technology expert, he used AI to find sources, which is, what we're all starting to do now to experiment to see what it can do. But he cited academic sources in his report, his declaration in support of this law that didn't exist. They'd been hallucinated by whichever tool that he ended up using. So lawyers challenging the law thought that the sources were generated by LLM, stands for large language model, and indeed they were. So just recently, I printed it out so I could read you a quote. On January 10th of 2025, a week or two before that, there was a motion to exclude this expert testimony. And basically what happened, that the expert tried to explain that, yes, he used AI to help him write his report. And he originally had put in brackets, like in his draft, fill in, or like they were placeholders for him to actually put in real sites. But when he used an AI tool to edit the document, which was his normal practice, because the AI tool was a pleasing machine, and again, these are words that I've taken from other experts. He didn't actually say it was a pleasing machine, but this is what happened. The AI filled the holes, filled those placeholders with sites. And so the author, this expert, didn't realize that he hadn't filled those sites. He thought because the placeholder notation went away. So he, I guess, forgot to go back and check. I don't know. It was just kind of embarrassing for him. And so there was an opinion written by, let's see if I can find the judge's name. It's a U.S. district judge in the District Court of Minnesota, issued an opinion on January 10th and said that unfortunately, this professor's citation to fake AI-generated sources in his declaration, even with his helpful, thorough, and plausible explanation, shatters his credibility with the court. And ultimately, I'll read you the final decision. The judge said that the errors undermine the report's competence and credibility, and thus the court excluded consideration of his expert testimony in deciding a preliminary injunction motion. So not a good result, and embarrassing for this person, because he's a really smart, accomplished person and very, very aware of these tools, but got duped by the tools, just like a lot of the lawyers and other individuals we've spoken about. Okay, so here is our, I guess maybe I'm supposed to wait until the 45-minute mark. I'm sorry, speaking too quickly, but this is the CLE code CDG25. The CLE code is CDG25.
All right. Well, it's when we talk to clients, sometimes there's, legal risk and then there's brand risk. And I feel like that's the same thing for us as lawyers as well, because as you were talking through that, I thought, $1,000 isn't great, but it's not the end of the world. But being embarrassed and shamed and having your credibility damaged in court in front of your peers and in front of judges you might want to go in front of before is actually a much harsher penalty in many ways. So that's definitely a lesson to learn.
You're absolutely right. And all of these cases that I've cited today are accessible online, and these attorneys and experts' names are in them, and it's a damage to our reputation when this happens. So you're absolutely right.
Yeah. So I know we have a couple more cautionary tales. I'll also say, I know there are a couple of questions in the chat, but I do think we'll have some time at the end to go through them. And I think they'll be helpful to come after we talk about, where we go from here and what some solutions should look like. So I'll give it back to you, Heidi, to close us out on the cautionary tale.
Cautionary tales. Okay. So yeah, this is the last category of cautionary tales, and just a trend that I found really interesting and also slightly, in my opinion, a little bit alarming. So in this particular situation, there's a law firm, again in New York, in which they help I don't want to use the word prosecute, but they help advance claims against the New York City Department of Education involving the Individuals with Disabilities Act. So it's the IDEA is the act in New York. And so these are cases in which people are making claims against the New York City Department of Education. And this one particular law firm has prevailed in the underlying litigation. And so as part of their success, they are entitled under this act to an attorney's fees award after they win the case. So here's where the problem comes in. In 8 different cases in front of different judges in New York pursuing these claims, they have unsuccessfully attempted to use AI to support their fee requests. So this is somewhat similar to the expert cases that we just talked about. So these particular cases actually attached an exhibit or an appendix showing their prompts and responses at interacting with ChatGPT to support their assertions of what the prevailing market rate is for the work of the attorneys and paralegals, junior attorneys, senior attorneys, experts in these IDEA claims. And they tried to prove up, hey, I'm giving you, judge, these ChatGPT interactions to support our fee request. They've done this 8 times. In all 8 cases, the judges rejected that evidence, disregarded, I'm using the language from the judges, they rejected, disregarded, and declined to consider or credit the quote evidence in support of the law firm's fee requests. And here's why. Based on the ongoing concerns with ChatGPT inventing false information, the tool's propensity to fabricate information, and its current reputation as an unreliable source. So I'm emphasizing current and then existing, and here's why. Oh, by the way, in all 8 of these cases, the law firm was still successful in at least recouping some of its attorney's fees for the client because they're statutorily entitled to it. But because the ChatGPT fee calculations were deemed unreliable, in all 8 situations, the courts substantially reduced the fee request. They still granted the fees, but on a much more reduced dollar level. Here's why I want to flag the language about current or then existing concerns about the reliability. Because as we know, and as the media is constantly telling us, these tools are getting better. So at least 2 of these 8 judges pointed that out in kind of subtle language, but to me, this language kind of jumped out as, this might not be the situation for this law firm forever. So here's what I mean by that. Judge Engelmeyer in this particular case wrote, barring a paradigm shift in the reliability of this tool, again, coming back to that reliability word, the firm is well advised to excise references to ChatGPT from future fee applications. And then Magistrate Judge James Cott said, in light of its propensity to fabricate information, ChatGPT, at least in its current iteration, should not be utilized to support a fee application. So to me, these 2 judges are kind of saying, right now, stop doing this. And I'm not a judge. I've never been a judge. I've always been sort of intimidated by judges. But if I were a judge in one of these cases, I'd be so annoyed that the same firm has tried this 8 times to no avail. And interestingly, I just did a search last week or the week before to make sure I hadn't missed any more recent cases, and I haven't seen any more cases. So maybe this firm has finally decided we're not doing this anymore. But these 2 judges, to me, left the door open that if there is a paradigm shift in the reliability of these tools, perhaps they would consider this type of expert evidence or this type of market evidence in a fee request of this type in the future. So I thought that was interesting and something for us to think about.
Yeah, no, that's helpful and accurate, because we are seeing obviously new models being released that have higher levels of sophistication. So there's hope for those looking for more efficiencies in their free request proposals. So we know there are obviously benefits. I think we probably all agree AI is here and we'll be using it and it's not going to go away. there are obviously pitfalls. So where do we go from here, particularly when I think about being part of the solution, but law firms and legal departments, should be thinking about steps about how to incorporate these new technologies safely. So maybe you can talk about some of the solutions.
Absolutely. So this slide and the next slide are really kind of taking a moment to reflect on everything that we've read and talked about today. The state bar ethics jurisdiction, the state bar ethics opinions that have been issued across the country, and the number of federal and state court judges who have issued really thoughtful standing orders. And then in considering all the case law that we looked at today, here's sort of a list of how we can together collectively educate ourselves and be part of the solution to instead of continuing to perpetuate these issues that we just saw in all these cases. So first of all, understanding that these tools still aren't perfect. Despite, I just constantly feel like when I check my phone every morning, I'm bombarded with the latest, greatest hype about AI and how it's gonna, like you said earlier, Jessica, take all our jobs, but it's not, because right now it's still, even the best legal AI tools still have limitations related to legal research. And also, I could talk forever about its limitations about legal writing as a legal writing professor, but let's first talk about legal research. And so therefore, it's not that we shouldn't use these tools. We absolutely should. In fact, Professor Ethan Mollick, who is sort of a generative AI guru out of Wharton at University of Pennsylvania, he challenges all of us to do the 10-hour rule. Like, we aren't going to know enough about these tools unless we've spent at least 10 hours using them on things that we just enjoy doing. It doesn't even have to be related to law work. But we can't wait for these tools to be perfect. We have to get to know them and make mistakes with them now in safe, circumstances with guardrails around them, so we know their limitations. So I just wanted to put out there that sort of 10-hour rule. Play around with it with research that doesn't have high stakes. It has very low stakes related to things that aren't part of our jobs, just related to travel or restaurants or whatever. It's so helpful to spend 10 hours with these tools just playing around. Then we absolutely, so we're not trying to shift the blame game, incorporate site verification protocols just as a normal process into our workflow. We've always done that, right? Through Shepard's and key citing, making sure our cases are still good law. But now we need to make sure they're actual existing law. And also the legal research tools that I've used so far aren't always giving me the most up-to-date cases or the most on-point cases or mandatory precedent versus persuasive authority. So this is just another step in our very normal legal research workflow to make sure that the cases we're citing are on point, accurate, exist, and the best cases for our purposes. We've seen kind of at all levels of experience in the law firm, we all need to be educated about these tools. Whether I still love marking up stuff on paper. Like, I'm old school. I am not a tech person, but we all need to be tech literate when it comes to generative AI, from entry level to senior leadership. In that regard too, let's create space and opportunities for open and transparent communication about how we're all using it, so we don't have those pitfalls of busy senior attorneys signing off on documents because that's part of our normal protocol. I mean, I remember being the brief writer and being a little nervous every time my boss would be like, "Oh, I trust you," and he would sign the pleading, and I'd be like, "Somebody needs to read this thing." But that's okay. Like, we have protocols that are normal based on efficiency and level of experience, but now we need to enhance communication about just doing that one more check about AI to make sure that we're all on the same page about how it has been used in any document that we're creating. We also, anytime we're using these tools, even for documents that aren't being submitted to court, anything we're writing using AI, whether it's like a marketing pitch or an email or a first draft of some sort of letter that we're doing, that's fine. But remember, it's a word prediction machine. So it's predicting the next most logical word in a sentence, which kind of makes the writing a little bit generic and boring. So we need to commit to making sure that we edit. We're not just outsourcing our writing to these tools wholesale. We are still what the experts are calling the human in the loop. and putting our eyes and brains into it to make sure that the work product is helpful to whoever is reading it. It's not just something generic or default that might answer the question, but isn't really helpful or moving the case forward for our clients. Absolutely, we need to make sure we're complying with judges' standing orders. And like I mentioned at the beginning, they're all different because judges, at least the early adopters, were worried about different things. So the judges' standing orders vary from court to court. And then I really feel like, I mean, I know that the work that you all are doing and the work that I do doesn't really involve pro se litigants, but the reason why I think it's important for us to think about that is kind of like, do we have a duty as a profession to educate the public? Because otherwise, if we're not, the public is relying on these tools, and then that adds a burden onto the law firm world and the judges and the court personnel to be checking all this, whereas maybe there's ways that the profession can help the public understand how to not get in trouble using these tools. Same thing about like free or cost-effective ways for the general public to check and do their site verifications. And then finally, for all of us who are working with experts on a regular basis, let's educate them or remind them. I mean, a lot of experts already know this, but remind them about the evidentiary standards in the particular jurisdiction where they're going to be rendering opinions, and make sure that they can back up what they need to about their opinions and calculations derived with the assistance of generative AI tools. Kind of like Judge Newsom at the beginning, he didn't use it as a substitute for his own judge brain to make those decisions. He used it as sort of a gut check or like an extra cross check. And I think that's okay for our experts to do as well, but just to make sure that they can answer complex questions about the reliability. So I'll leave it at that. We can start talking about questions. I did write an article summarizing all these cases. I'm actually revising the article because we're now up to 39 cases total. But back in November, this link leads to I think there were 34 cases at that point. So if you're interested, there's the link to that.
Great. And I think you did say you were willing to make the deck available so we can circulate that to attendees after the call.
Yes, absolutely. And then here's my contact information if people have follow-up questions, and that'll be at the end of the deck as well. But should I stop the share and then we can take questions?
Sure, let's jump into questions. And two of the first questions that came in were on contracts. So, how reliable is ChatGPT for providing, random contract clauses? Give me a good mutual indemnity clause or whatever someone wants, and more importantly, how often does it hallucinate?
That's so interesting. So yeah, I mean, it is very good at giving language and varying that language. So I don't know how often it hallucinates in terms of drafting contracts because, contract language is not tied to a citation necessarily. The way that I've used it is I don't just ask it to give me one answer. I'll say, give me 5 sentences that mean X, or give me 10 examples of XYZ. So I would say in the contract context, ask it to give you multiple examples of particular contract provisions, but also give it context. So this whole conversation today is not about prompt engineering, but the experts on prompt engineering have said the more context we can give these tools, the better. So you want to give it a role, context for who you're representing on it in a transactional engagement. Like, are you the insured or the insurer, right? That's going to be a totally different clause and who it's going to protect. So wait, I was going to say, you give it a role to play. You are a drafter of a contract. The context is it's a construction project contract. You give it the format you want it. So if you just want a provision, you can say, give me a concise yet thorough provision related to indemnity. And then, format and tone, you can give it, make it really assertive, or you can make it very fair. You can give it all of that, but go through those sort of role, context, format, tone kind of thing. And then ask it to do it multiple times. I think that's called chain of density prompting, is when you have it generate an answer, but then you have it tell you what's wrong with its own answer. And the density of having it iterate and iterate and iterate will help you get to a really solid contract provision. But there's a lot of resources out there on prompt engineering for that exact purpose. The hallucination side I haven't really seen in terms of contracts, because it's just giving you language and giving you word after word after word, which is actually pretty good at.
Yeah, I agree with that. I'll say from my own experiments, with some of these tools, to your point, if you give them you're this type of lawyer representing this type of client in this jurisdiction, even these are my key concerns, I don't want to go over this super cap. I don't want to, whatever kind of the parameters are that you're aware of, it is pretty good at least giving you a first draft at some of that language. And you can kind of go back and iterate and say, make this shorter, make this stronger, more protective on this side. And also think about what platforms you're using. Because if you ask Claude the same question that you ask ChatGPT, you'll get different answers. And depending on the context, you might like one better than the other.
Absolutely. I was going to say that too. Like, make it do it multiple times and do it on multiple platforms and compare.
And then I also just encourage, if you're going to use it, try to use like I think many of them do this, like Notebook LM and Perplexity and ChatGPT. If you ask a question and you're concerned about indemnity, so maybe you're not writing a clause, but you're saying what's market standard for this type of provision, it should give you links, and you should check those links, because sometimes those links are helpful and accurate, and sometimes they aren't, and you can try to get ahead of some of those hallucinations.
Absolutely. And I think all the legal research platforms now have a drafting AI tool, and you might try it again on the legal platforms as well. And they might provide links to forms and templates and things like that.
Yeah, and then always if you have your own templates, you can upload those and say, like, this is generally, again, when using this, should be doing it in an enterprise contract under an
Yes.
agreement. So it's not to get training on your data, but assuming you have that in your organization and that's been approved by your legal department, then you can, if you are able to upload contracts or sample contracts, it can take that language and spit out something similar, which might be more specific to what you do.
Totally. And in the vocab of generative AI, giving it examples is called, it's either zero shot if you give it no examples, it's one shot if you give it one example, and it's called few shot if you give it a few examples. So again, do it within the bounds and guardrails of your privilege and confidentiality parameters, but you can give it examples, and that is good to help it get more precise with that other template I gave you for prompting, like role, context, format, etc. Give it examples.
And there was a follow-up to that. Understandably, it's important to verify through other sources any info that ChatGPT would provide. But again, I guess this is more again about hallucinations and accuracy. So I think we've answered that, but I guess any other last takeaways on the hallucination accuracy question?
I would, definitely check everything and be a little skeptical, because the answers you will get, even if it's not a citation to a case, will seem really confident. But that's when I always am like, there's something slightly off about that. Like, if I hadn't known that judge was from Texas, I would have believed that Brantley Starr was a Texas judge. So just always check and verify every little thing. But I know we've already said that.
And last question, which if you don't know, we can circle back after, was, do we know how the IRS feels about AI used in valuation reports by experts?
Oh my gosh, I don't know that, but one of the cases is in the tax court. One of the hallucinated cases is in the tax court. I think I might have pulled that slide, but so the IRS is aware, the tax judges are aware that this is a concern. I don't actually know about that particular answer to that question, but I actually didn't have access to the tax court opinions. And when I was talking about these cases before, a tax lawyer reached out to me and he said, hey, you should know that the hallucination problem is happening in tax cases as well. And so tax lawyers should be aware of how that's being handled by judges. But I apologize, I don't know the valuation question.
Same. Me either, although I did see the IRS plans to use AI itself in its auditing process, which there was a lot of pushback about
Mm-hmm.
online. And so you imagine there's some openness to it, but we don't have concrete answers there. We're at the top or approaching the top of the hour. I just want to say thank you so much, Heidi. This is really informative and helpful. If there are any last questions that come in, we can answer those via email, but I want to make sure everyone gets off to their next meetings in time. So
Thank you.
Heidi, and thanks for everyone for joining us.
It was fun teaming up with you, so I really appreciate it. And I know I speak a mile a minute because I get so excited about this stuff, but happy to answer questions on a more slow, calm basis if you have any more.
That sounds good. Thanks. We appreciate it.
Thank you.
Take care, everyone.